Good afternoon, everyone. See, I'm giving you advance notice to take your seats before I even get up to the stage. If you could go ahead and take your seats, we are thrilled for you to be joining us for this breakout session entitled How to Secure Equal Rights for All. If you guys don't know me, I'm Melissa Oden, the founder and the CEO of the Abortion Survivors Network. I know many of you have stopped by our table. We're grateful that you're learning about how babies like me survive abortions. Babies survived before Roe. Many babies like me survived during Roe, and babies are still surviving today, mostly by chemical abortion pills. So real briefly, what we do at the Abortion Survivors Network, we do a lot of advocacy and awareness, educating people about the fact that babies do survive abortions. That tells us about the humanity of every preborn child and their dignity and value. We also provide lots of support to abortion survivors throughout the continuum of their life, as well as support mothers who experience failed, stopped, or reversed abortions, as well as adoptive parents who often struggle with how to support a survivor, how to even talk about this. So if you haven't checked out our work, we love what we do, and we love getting to partner with organizations like Students for Life and all of you. So happy to introduce this panel today that I am excited to hear from. I will introduce our three panelists here. You guys know them, but feel free to give them a round of applause when they come out today. We have Josh Craddock with Live Action and the James Wilson Institute. Woohoo is right. We also have Patrina Mosley, whose testimony before Congress I rely on quite frequently. So Patrina is a speaker, author, and advocate. And then we also have Michelle Hendrickson with the Mary Dimitri Institute for Pro-Life Advancement. Thank you so much for joining us this afternoon, panelists.
Great, thanks so much. Well, it's a pleasure to be with you all today. I'm so glad to see folks who, I know many of you were out there at the march. I was with you walking through the snow and the slush and enjoying that. So thank you for being here. I want to talk about how for the last 50 years, we marched with a goal in mind. And that goal was the overturn of Roe v. Wade, right? For 50 years, we marched to overturn Roe. And in 2022, in the Dobbs decision, Roe was finally overturned, right? So it was a massive victory. And now as we look forward, what is the next goal? What are we continuing to march for? And I want to offer you the North Star of our movement and argue that that North Star is the same that it has always been, that it is equal protection for the unborn, right? Born and unborn. Now, a century and a half ago, thank you, yes. Now, a century and a half ago, we fought a civil war and we amended the Constitution to ensure that every human being would be protected as a human person. But some states, as you know, today continue to deny that protection to children in the womb through abortion. Now, from the moment of fertilization, those victims of abortion are human. And in our legal tradition, every living human being is a person. And our Constitution in the 14th Amendment says that no state shall deprive any person of the equal protection of the laws. And so that is why abortion is unconstitutional. So in Dobbs, the Supreme Court ruled that Roe v. Wade and Casey versus Planned Parenthood would be overturned, and they held that, quote, the Constitution does not confer a right to abortion through the 14th Amendment. But as significant as Dobbs was, it actually only corrected one of Roe's legal errors. Nothing is left standing of Roe and Casey, but only one of its legal errors was corrected. Because in order to say that the Constitution protected a right to abortion, the Roe court first said that preborn children are not persons within the meaning of the 14th Amendment. If personhood is established, Justice Blackmun wrote in Roe, then the case for abortion collapses. For the fetus's right to life would then be guaranteed specifically by the 14th Amendment. Now, the justices in Dobbs were not asked to opine on the question of personhood. It wasn't presented by the parties. And indeed, they didn't have to answer that question in order to answer the question presented, right? They could hold that pre-viability bans on abortion are constitutional without addressing the further question of personhood. But we must ask, are children in the womb persons within the meaning of the 14th Amendment? Is abortion unconstitutional? Now, the 14th Amendment was ratified after the Civil War in 1868 to ensure that no human being would be denied basic legal rights. So I want to, since we're going to be talking about it, let's look at the text of the amendment itself and break it down. So the first clause of the amendment is known as the citizenship clause. It says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. So this is the citizenship clause. Now, a lot of people stop me right here. They say, Josh, how could you be arguing that the unborn are protected by the 14th Amendment when it says born right in the first sentence? Well, it's important to understand that it's not defining person, it's defining citizenship, right? We're taking this broad and undefined class of persons and narrowing it down to its subset, citizens. Citizens have to be born or naturalized and subject to the jurisdiction of the United States to be a citizen, right? But person is not defined that way. So the next clause is the privileges or immunities clause. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizenship, right? As citizens, there are certain things you have, some privileges you have, like voting, for example, right? So this is the subject is citizens here. But notice as we move into the next clause, the due process clause, the subject changes. Rather than citizen, now we're talking about, I see you see it on the side here. Now that instead of citizen, we're talking about persons. So it says, nor shall any state deprive any person of life, liberty, or property without due process of law. And then the equal protection clause, nor deny to any person within its jurisdiction the equal protection of the laws. So understand section 1's application to preborn children as persons. Let's use 3 different interpretive tools. First, we could look, because the term isn't defined, we can look to definitions in dictionaries or of common and legal usage, right, to figure out what the meaning of person is. We can look at historic state practices related to abortion. And finally, we could look at the drafter's original understanding. So first, if we look at definitions, according to dictionaries of common and legal usage, at the time of the 14th Amendment's adoption, the term person was interchangeable with the term human. So the 1864 edition of Noah Webster's Dictionary of the English Language defined person as relating especially to a living human being, a man, woman, or child, an individual of the human race. In legal usage, every human being was considered a natural person. So the authoritative treatise writer, William Blackstone, actually begins his commentaries on the laws of England with a discourse on the rights of persons. And if you can believe it, William Blackstone, this great treatise writer who every founder of the United States would have had a copy of his commentaries on his shelf, he actually begins his discussion of the rights of persons with a discussion of the unborn child's right to life and personal security. He wrote that life is a right inherent by nature in every individual. And for Blackstone, if human life could be shown to exist, then legal personhood existed also. So second, let's look at state practice. There were centuries of common law precedent that was inherited from England in the colonies when they became independent. And that common law precedent consistently treated the preborn child as a person whenever it would be for his or her benefit. So based on authorities like Lord Blackstone and Cook, who were treatise writers, as well as landmark English cases, state high courts in the years leading up to 1868 consistently recognized that the unborn child throughout all of pregnancy, quote, is a person, and hence under civil and common law, to all intents and purposes, a child as much as if born. Right? That's from 1838 in Massachusetts. Now, at common law, abortion was unlawful at all stages of pregnancy, and it was typically criminally indictable as soon as the woman was quick with child, which was a phrase that had shifting meanings. Some courts understood this to be as soon as the child was alive or quick. Other courts understood this to be as when the child's life could be detected by the mother, sometimes called quickening. But this rule was designed to protect life as soon as it could be shown to exist, not to exclude protection prior to that point. The proper principle to derive is that as soon as life could be detected, it was protected. Now, by 1866, this quickening distinction had basically been abandoned by all jurists. And in fact, Chief Justice Tenney of the Maine Supreme Court accurately reported by that time that the quickening distinction has been abandoned by jurists in all countries where an enlightened jurisprudence exists in practice. Now, when the 14th Amendment was adopted in 1868, the states widely recognized preborn children as persons through all stages of pregnancy. So nearly every state had, in addition to its common law prohibition against abortion, had codified a statute prohibiting abortion, defining the elements of the crime of abortion by statute. So not only did these states prohibit abortion at all stages, but 28 jurisdictions labeled abortion as an offense against the person, right? So there might be offenses against property, maybe like trespass or something like that. And then there's offenses against the person, like homicide. And that's where abortion was classified in these state statutes. In fact, in 23 states and 6 territories, the statutory laws referred to the preborn individual as an infant or child. And the same Ohio legislature that ratified the 14th Amendment in January 1867, just 3 months later convened to consider one of those statutory prohibitions on abortion. And some of the same senators who voted for ratification wrote in their report that abortion at any stage is nothing less than, quote, child murder. So very strong language coming from 1867. So the third thing we might look at is the framers' understanding of the amendment's legal application, right? What did they understand the guarantee of equal protection and due process to accomplish? And Senator Jacob Howard, who sponsored this amendment in the Senate, he declared that the amendment's purpose was to, quote, disable a state from depriving not merely a citizen of the United States, but any person, whoever he may be, of life, liberty, or property without due process. And even the most despised of the human race were guaranteed equal protection. As Justice Hugo Black later put it, the 14th Amendment, people were told, the history of the 14th Amendment proves that people were told that the purpose was to protect weak and helpless human beings. Now, one mistaken approach to constitutional interpretation might claim that the 14th Amendment doesn't protect preborn children because it was most immediately designed to protect Black Americans from discriminatory, unequal treatment. But the amendment's framers deliberately chose a broader term, any person, to accomplish and to affect any human being who might be denied due process and equal protection of the law. They deliberately chose that broader language to apply to future circumstances. Another mistaken argument might rely on the fact that constitutional rights are typically only enforceable against the government, right? Not against private actors, right? You can't sue your parents for violating your freedom of speech because they tell you to shut up, right? You can only sue government officials and officers and government actors for violating your constitutional rights. And that's called the state action doctrine. So a state's failure to protect an individual from an act of private violence typically isn't considered a constitutional violation of due process. So how could abortion be unconstitutional? Well, the Supreme Court has long recognized that the state may not, of course, selectively deny its protective services to certain disfavored minorities without violating the Equal Protection Clause. So imagine if a state passed a statute and said that it's lawful to commit a homicide with malice aforethought so long as the victim is Black or of Croatian ancestry or left-handed. Right? These would be obvious constitutional violations and denials of equal protection, and the state action is the legislative act to pass such a law, right? That's why we call it an act of Congress or an act of the legislature, right? So that's where the state action comes in that makes state denial of equal protection unconstitutional. Now, nothing I've said today is a new idea. All of this has been around from the time of Roe itself. Right? The state of Texas, in its initial arguments in Roe, argued that the fetus is a person within the meaning of the 14th Amendment, right? Any Texans out there? All right, yeah, there we go. Good. Not only that, even President Reagan agreed that the 14th Amendment applies to the preborn. He actually issued a proclamation in 1988 on the occasion of the March for Life, in which he declared, quote, "The well-being and the future of our country demand that protection of the innocents must be guaranteed and that the personhood of the unborn be declared and defended throughout the land." So where does that leave us after Dobbs? I think every level and branch of government has a role to play, right? Beginning with the states. Obviously, every state has an obligation to exercise its general jurisdiction to enforce the equal protection guarantee and to protect its unborn residents from the violence of abortion. But there's an inescapable federal role to play as well. One of the mistakes of people trying to characterize Dobbs is they've often said that it leaves the abortion policy to the states. That's not an accurate representation of what Dobbs held. Dobbs' holding was that there is no constitutional right to abortion. Now, the practical implication of that decision was that now the states are enabled to prohibit abortion, right? But they did not reach the personhood question. That is the subject of litigation and legislation going forward. And we're going to hear more about how that's going to be played out. But the 14th Amendment gives Congress an enumerated power to, quote, enforce by appropriate legislation the guarantees in the amendment. So that's in Section 5. Our federal government is not supposed to legislate on things unless they have an enumerated power to do so, right? And that's where the enumerated power to protect unborn children comes in. It's in Section 5 of the amendment, to enforce by appropriate legislation the guarantees of Section 1. As the Supreme Court explained in 1880, whatever legislation is adapted to the equal protection of the laws against state denial or invasion is brought within the domain of congressional power. So that's Congress. What about the president? The next pro-life president, who understands the Constitution's protections for life, can instruct each department and agency under his or her purview to, within their realm of authority, recognize and protect human persons in the womb, right? So the next pro-life president can instruct, for example, the Department of Health and Human Services to instantiate this understanding of equal protection under the 14th Amendment and to, for example, prohibit the distribution and sale of chemical abortion drugs. And finally, the courts. They have an obligation to apply the original meaning of the Equal Protection Clause to ensure that those protections are guaranteed to unborn children. Preborn children are constitutionally entitled to due process and the equal protection of the laws, and the Constitution, properly interpreted, prohibits abortion through the 14th Amendment. And every government officer who swears an oath to uphold the Constitution has an obligation to ensure that those rights are protected. In America, abortion is unconstitutional. Thank you very much.
All right. First of all, I want to say thank you all for being here in the snow, in the cold, per usual. You guys are relentless. So, all right, we're going to keep going here. I want to recap just really quickly what my colleague just finished saying to you, is that the 14th Amendment guarantees due process and equal protection to all persons of the human species, and that includes the unborn. That's not complicated. Unless women are conceiving raccoons and all of a sudden they become human beings once they're out of the womb. I don't know. But if we're going to go with the natural understanding of persons, it's safe to say it's a child, okay? And equal protection for personhood is an easy, simple concept that was sovereignly placed in our nation's Constitution. The world's greatest Constitution, in my opinion. Why? Because it contains marvelous displays of biblical wisdom, biblical principles, and forgiveness. Though our founding documents hold simple natural truths, our country has not always lived up to them. And it took courage of people like you to change our nation and ultimately change the world. The simple understanding of equal protection of personhood has been used to correct injustices in our culture, primarily on the issues of race and womanhood. So we're going to do a little bit of a history lesson real quick, and we're going to look at a few notable cases where the natural understanding of the 14th Amendment changed the course of our country. Let's see here. It was on the sides. Oh, okay, I'm looking at the wrong screen. I'm like, why is the screen not changing? Okay, there we go. All right, so the first case, Dred Scott. I know many of you may be familiar with that, but it's also Dred and his wife, Harriet. They're always trying to leave women out of stuff, but we're not going to leave women out. It's her too. Say her name, okay? Harriet Scott. And so Dred, he was a slave that was taken back and forth between slave states and free states with his owner. And in the free states, there was a Missouri Compromise that said that once you enter this space, you are free. So he, towards the end of his life, sued for his freedom. Him and his wife sued individually based off the statute in a 1920 Missouri Compromise. And they argued that freedom should not be revoked once you're in a slave state and then go to a free state. And he also argued that this Missouri Compromise statute applied to him because he was a U.S. citizen. So, unfortunately, the courts at the time said, no, sorry, Dred, sorry, Harriet, because you are of Negro descent, you are not a U.S. citizen. And just because you went to a free state, you are not entitled to freedom. Case closed. But the good news is that at the end of his life, he died in 1958, but there was a civil war that came, as you all know. This case actually helped propel the Civil War. And although he didn't get to see his case overturned, but when the Civil War was over and we were united as a nation that emancipated the slaves, that overturned the Dred Scott case, and Negroes were counted as citizens and entitled to freedom. As per the 14th Amendment, they were persons and U.S. citizens. Thank you, Fourth Amendment. Okay, number 2, as you can see here, is the Brown versus Board of Education. Fun fact, it's not just one case. That case was actually a consolidation of 5 other cases from 5 other states, including Kansas, South Carolina, Virginia, Delaware, and D.C., relating to the segregation of public schools on the basis of race. African American students have been denied admittance to certain public schools based on laws allowing public education to be segregated by race. But in this case, the plaintiffs argued that such segregation violated the Equal Protection Clause of the 14th Amendment. Now notice this case is in 1954. The 14th Amendment was ratified in 1868. And we're gonna kind of wrap up on why these cases are important and why we're pinpointing a few cases in history, and you'll see some of the hypocrisy, but I'm gonna tell you why there's such hypocrisy. So in that case, it did win, thankfully, and it overturned some other court cases that said that, yeah, you're okay to be separate but equal. Separate is still equal, and in this case, the Brown versus Board of Education, they said no, under the 14th Amendment, no, you can't do that. Okay, the next one is the Civil Rights Act of 1964. We all know about that. Martin Luther King Jr. and so many other great civil rights leaders helped usher this movement forward. But this act sought to prevent voter suppression, and it also told public institutions that you could not discriminate on the basis of race, color, and national origin. But how many of y'all know that, I'm gonna put it like this, was this the first Civil Rights Act? You guys are smart. Okay, yes. No, this was not the first Civil Rights Act. The first one was in 1866. Okay, so the Civil Rights Act of 1866 did not address political rights, which included the right to vote and the right to hold public office. The 15th Amendment, at the time, ratified in 1870, guaranteed to all United States citizens the right to vote regardless of race, color, and previous conditions of servitude, i.e. slavery. Okay, even so, the 15th Amendment had little impact for almost a century because states imposed poll taxes, literacy tests, and other restrictions that kept African Americans from voting. The Civil Rights Act of 1964 and the Voting Rights Act of 1965 were taken to address this problem. So you had the Emancipation, 1865, then you had the 1866 Civil Rights Act, then you already had the 15th Amendment, and then you had the 1965 Civil Rights. It's like, how many more legislations do you need to say the same thing? Okay, let's continue. Lastly, a woman's right to vote. From 1848 to 1920, suffragists advocated for state and federal constitutional amendments. Okay, I'm gonna repeat that. They advocated for state and federal constitutional amendments that would give women the right to vote in the United States. And what position did they argue? The 14th Amendment. The 14th Amendment gave Congress the power to pass new laws to enforce privileges of immunities of U.S. citizenship. And in 1871, Victoria Hall, which was a leading suffragist at the time, petitioned Congress to pass a new law recognizing women's right to vote as a privilege as a U.S. citizen under the 14th Amendment. Though women voting has given us a lot of liberal policies, so we're just gonna keep moving past that. But still, even at this time, the majority of black men and women were not able to vote due to Jim Crow laws until the Voter Rights Act of 1965. The 15th Amendment was ratified in 1870, which says the rights of citizens of the United States to vote shall not be denied or abridged by states or by any state on account of race, color, or previous condition of servitude. So, what does this history lesson tell us? It tells us that just because the law establishes a truth doesn't mean you don't have to fight for its enforcement. Just because anything establishes a truth doesn't mean you don't have to fight for its consistent and righteous application. It was 400 years until the slaves were free in the land of the free. Another 100 years to end Jim Crow laws and to gain civil rights. Another 100 years for women to be counted as U.S. citizens and the right to vote. In all of these circumstances, the natural common sense meaning of the word person was suppressed to accommodate contrary agendas. Evil people with evil agendas will invent new ways to do evil. Truth is not a given, and you have to contend for it. That is because we're in a battle between darkness and light. Nothing is a given. You have to keep going. You have to keep pushing for what's right. You have to keep going in what's right and true, and that requires persistent and consistent enforcement. And one of my favorite quotes is that the right time to do the right thing is right now. Martin Luther King Jr. In the case of abortion, the common sense meaning of the 14th Amendment saying the state shall not deprive any person of life is the polite way of saying people don't have the right to murder you. We have laws that typically prosecute this crime, and that's because life is given by God, not the state. And people don't have the right to take innocent life. Abortion is a great evil in our time, where one can simply be discarded for being inconvenient. As many politicians are discussing limits on abortion, let us remember the goal is to make elective abortion unthinkable. Just like today, slavery would be unthinkable. Separating people by race, color, or national origin would be unthinkable. As someone once encouraged me, and I'll share this with you, and hopefully it will encourage you, is that it may feel like we're in the minority, but we are right. We remember and continue to talk about the contributions made by fearless pro-life advocates that expose the evil of the abortion industry and the humanity of the child in the womb, such as the baby body parts for profits investigation. Remember that? We don't stop talking about that. The prosecution of abortionist Cornell Gosnell, the testimonies of former Planned Parenthood workers like Abby Johnson and the others who I know are here today. These people left their livelihoods to blow the whistle on this blood business. And yes, we remember the justice for 5 victims whose faces we did not look away. Remember their faces and lifeless bodies on the way to be turned into biodegradable fuel. We remember and expose and continue to talk about obtaining justice and making this corrupt industry pay for the harm they have caused to countless lives, particularly with the unsafe and unethical FDA approval of abortion pills. This is why we march, this is why we petition, and this is why we vote. Remember, just because something is true and is in the law does not mean that we give up. It does not mean we stop fighting. We must remain persistent for consistent and righteous enforcement of the law for all persons. Thank you.
Well, I am so thankful that Josh and Patrina did all of the hard work, and I get the fun part of how do we package this all together in a message that can work. So again, my name is Michelle Hendrickson, and I am truly blessed to lead our Dimitri Institute for Pro-Life Advancement, which is the research arm of the pro-life generation. And in the summer of 2023, we conducted a study assessing the best possible messaging to pro-lifers on the viability of using the 14th Amendment as our next national rallying cry. What has been especially interesting for this piece is it's a little bit of insider baseball today. What I'm about to share with you, we have never actually published on our Institute for Pro-Life Advancement website. So you're truly getting the inside look here. We have only shared this with leaders of other pro-life organizations. But a little bit about us. This is what we do. If you have never heard of the Dimitri Institute for Pro-Life Advancement before, we provide research, messaging, and innovative action unifying the pro-life movement to end the violence of abortion. So there are some recent studies just in the past just in the past couple months, 3 big projects that I won't have time to go into today, but just so you're aware of the work that we do. In December, we released the Christian Schools Project, one of my favorites, and we researched the possible connection between Christian schools and Planned Parenthood. And yes, sadly, 1 in 10 Christian universities in this country have a relationship or connection with Planned Parenthood. Anything from inviting them onto campus as a speaker or actually referring out to them. So go online and read that study and see where, if you go to a Christian school, where they lined up. In November, we did our own exit poll in Ohio for the election there to learn about the youth vote in Ohio on issue 1. We learned that 85% of those who were motivated to vote no did so because they wanted limits on abortion. They did not want abortion through all 9 months. So that taught me we have to talk about abortion during ballot referendums. And then finally, just this month, we released a national youth vote poll that showed more than 6 in 10 youth voters want limits on abortion. Again, the majority do not want abortion on demand through all 9 months. But those are studies that you can find online. Back to the 14th Amendment and our methodology for this one. So for this study, again, this was actually an internal study where instead of researching public opinion, we researched you guys. So you may have actually participated in the survey if we sent out an email to our student list and our supporter list, and then there was also a consumer panel. But we wanted to know what you guys think. We wanted to know what messages would inspire you, the pro-life movement, to champion the 14th Amendment, and is this even possible? So we did qualitative interviews with leaders within the pro-life movement, and then we did an online survey through our list, again, supporter list, and then this online consumer panel. And what this taught us, first, as a baseline, we asked, how is the pro-life movement doing today? How is the pro-life movement doing today? How would we rank ourselves if we're being honest, from struggle bus to surviving, thriving? Where are we? So some good news I have for you that you can see here, that the movement is perceived overall as doing well. Not totally thriving yet, but we perceive ourselves as doing well. We're aware that this is not nearly over. The next thing we learned is when pro-lifers reflected on the greatest need in the movement, there were so many things that they were able to respond to. This was a multi-select, so they could select more than one. The idea of a national rallying cry, having that one thing, it was the lowest. So it just wasn't on the minds of the general pro-lifer. They chose it about 1/4 of the time, but it was the lowest of their priorities. And this taught me 2 things. I saw 2 things in here. First one, y'all just love to love. You love to serve. Service is on your mind, right? We are so focused on changing minds on campuses, spreading awareness of pregnancy help centers. You do the good work. That is where your mind is. But this, the second thing is, this helps leaders. So if you're the leader of a pro-life organization or you aspire to be one day, this helps us realize that the general pro-lifer isn't focused on national strategy, for better or for worse. It's just not where their mind is. And that's okay, it's understandable. But we have to reach that general pro-life person who shows up to march, and then they go home all year long, and then they just kind of do their thing, and they really haven't thought beyond their next service project. That is a challenge we have to be aware of, that they are not tuned into a national strategy, for better or for worse. The next thing we learned, some good news though, is that while a rallying point wasn't naturally chosen, almost everyone agreed, yeah, we need this. So here are some direct quotes from leaders, some pro-life movement leaders who you're actually hearing from at this conference today. Now, they're unnamed. I'm not going to tell you who's who, because it's a study. I'm not going to reveal who it was. But some people are here today, and they said things like this. There is a bit of a vacuum and not much consensus now in the movement as to what the goal is. Here's another one. There has become a question of what we're rallying around nationally. There's a need for something that we can all get behind. This longer one's interesting. We always said that the goal never should have been overturning Roe v. Wade. That was a strategy and tactic along the way to the ultimate goal, which in our view is to make sure every child and parent has abundant life. The pro-life movement for decades thought the goal was to overturn Roe. So when it got overturned, I don't think that we came up with a new goal. These are the leaders of the pro-life movement. Where's our goal? What are we doing? What's going on? Here's my favorite. How do we go from a post-Roe to abortion-free? The ultimate goal is to stop all abortions. Come see us at the Abortion-Free Cities panel right after this, because I'm on that one too, and I'm so excited how to talk about how do we get there? How do we do this? How do we get to abortion-free? What is that national rallying cry? So there is a clear need, but what challenges might we face, and what messages work best? Well, the first challenge is going to be our familiarity with the 14th Amendment. You know, I've heard Josh give that speech twice now, and I still feel like I learned something new. I am a girl of many talents. I helped lead this research study. I could make homemade gnocchi with my eyes closed and no recipe. It's delicious. Do not quiz me on the Constitution. I'm not going to get it right. I was just taking notes furiously back there. And you know what? That's true for most pro-lifers. They have not heard us as leaders talk about this. And only about 10% in this survey were confidently familiar in the 14th Amendment. So this means we may face the challenge of educating people on the 14th Amendment first. Or is the best message one that highlights pieces of the 14th Amendment that are important and work in a way that can inspire them? So I'm going to go through super fast the 4 storylines, we called them, the four messaging stories that we walked people through as they did these interviews, as they did these surveys. And each story had a basic theme. Each story picked out sections of the 14th Amendment to see what would resonate, and then they sort of reacted to them and ranked them, and we'll get to the results of which stories performed better. But just to walk you through all 4 storylines, it's really 3, and then the third one kind of took a turn, so we made like a 3A and a 3B. But here's the first one. Here's how that first storyline goes. The theme was win the war for good, and then we pulled out the originalist interpretation. So it went something like this. The 14th Amendment will allow us to win the war on abortion for good. An originalist interpretation allows for protection for all human beings in the womb because abortion was illegal both when the document was originally written as well as when the 14th Amendment was ratified. Therefore, we can be confident that the 14th Amendment can be applied to protect preborn life. And then the last one is the same for all the stories because it's the end result of the goal of, therefore, we must elect a Congress who will apply the 14th Amendment. So that's story number 1. I'm not going to give you the results yet. You got to wait. Story number 2. The theme here is hope. Who doesn't love hope? Hope that all persons can be protected. And it acknowledges what we saw in a lot of the qualitative interviews that, man, there's still a lot of work to do. We're not done yet. So this message incorporated those pieces. And story number 2 sounded like this, that we have hope to see all human beings regarded as persons and therefore protected from the violence of abortion. There is still work to do to ensure systems are in place to support pregnant women and to legally protect all humans born and preborn. The 14th Amendment already allows for such protection to be applied to preborn persons and is attainable. There's that hope again. It is attainable within our lifetime. You know, at Students for Life, we said that a lot about overturning Roe, and we were called crazy. And here we are, and I love it. So this is attainable. I'm going to claim it. This is attainable within our lifetime. We have hope. And again, therefore, we must elect the right Congress people. All right. Story number 3, and this is sort of the first of 2 versions, talked about that idea of personhood. You heard that talked about a lot with the 2 speakers before me. Personhood for all, and we highlight this history of wrongs and other human rights atrocities that we've committed where the 14th Amendment has defended vulnerable people groups. So here's storyline 3A. It says, we have lost sight of the importance of securing personhood for all. History has shown countless examples when attributes of human beings were used to define a group of non-persons, resulting in discrimination or violence. The 14th Amendment gives us the opportunity to protect all human beings and avoid personhood abuses in the future, and of course, therefore, elect the right Congress. You guys get the deal. Now, last one. A little twist on the personhood messaging here. This is personhood for all, but focusing on due process and defining what a human person is. And this one kind of has a little bit of everything. It's a little bit of a cheat message because it also talks about the originalist interpretation as well. So we're trying to make everybody happy in this one. But I really think the flow of this final message is what won the day. So I will show you the results now. For all of our stories. So after reading through each story, the respondents reacted, and here are the results across all audiences. I think I deleted my own key out, so you don't actually know what those bars mean. The black bar is the response of our students. The red bar is the response of our supporters, adult donors, and the blue bar is that of the consumer panel. And you can kind of already see the consumer panel was a lot less picky than you all. So I don't know, when you're in your own work, you're just really particular. And so I kind of noticed that across the board. If it was a consumer panel person that's not necessarily within Students for Life, they were kind of happier, like, yeah, that sounds good, yeah, that sounds good. Y'all were really picky about story 1, so that was the first thing I noticed. Story 1 was the only one that had significantly lower scores. That was that language, if you remember, winning the war and this historical originalist interpretation. Those are all logical things. They weren't very inspiring, right? They weren't very inspiring. The story of hope and that first variation of personhood for all, those were decently received. I mean, it's a big deal that over half, found that these were enthusiastic, very enthusiastic messages. But consistently, the highest scoring message, was story 3B. And it had a little bit of everything, but mostly personhood in regard to due process and equality for all, and what we know science says about human beings. One thing we learned, though, is that there is so much more to explore. So one thing that this study did was we packaged these 4 storylines, but then we let the person taking the survey pick out single lines from within any story and make their own story. And well, they loved that a lot. Like, well, let me just, give me the driver's seat here, and I'm going to tell you how to make it. And so I'd love to tell you that we could figure out exactly what that storyline is, but it was unique for all, over 1,000 survey respondents, so you're never going to know exactly which one. But what we do know from this is that people are excited about using the 14th Amendment, and what we could pick out is which of those lines were chosen most often when they made their own story. So I'll close with the top messages, and I believe they are the ones that concerned our goals. Go figure, people want to know where we're going. Just tell me where we're going. Like, I'll get in if you could explain it to me. So it involved personhood, goals, and history. So top line message was the preborn are members of the human species from the moment of fertilization, right? We want rights at conception. You're pro-lifers, you get this, and man, if everybody else would just get this too. And then the next one was on our goal. We need to elect the right Congress. If any of this is ever going to happen, the next one was about our history. Let's not repeat the past, let's learn from it. We never want to see these human rights atrocities again. And then finally, acknowledging that there is still good work to do, because that is always humbling and important. So here are just some final thoughts for you all as we're the wheels are turning about this national strategy. It should give you goosebumps that we have so much to do that is good and attainable, that we can do this, that there is an appropriate national rallying cry. The need for the unifying message is so critical to get us all on track, to get us all unified and together. And the response to the 14th Amendment as that rallying cry has potential, it has promise. However, we need to find the right story. This tells me there's a little bit more testing that we need to do. So I'm excited to explore this topic with you throughout the next year. Please make sure that you're checking that Institute for Pro-Life Advancement website, because that's where we are going to publish all of this research for how you can make a difference in your community, in your church, and on your campuses with this information. And that's it. I will see you at the Abortion Free Cities panel next. See how I plugged that a couple of times. Thank you all.